The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning. Before I announce the cases that will be heard and considered and submitted this morning, let me first welcome to the courtroom the students from Panora High School, Des Moines Scavo High School, and Hampton Dumont High School. And any high school students following us online this morning, we welcome you as well. And I think there's even some students from the University of Iowa. The reason why we have a little more participation in our courtroom this morning is today is Constitution Day, and it's important for all of us, not just students and lawyers, but everyone to pause and consider and reflect upon the value of our Constitution and the constitutional form of government that we have, and the Constitution itself, both our nation's Constitution and our Iowa Constitution. These great documents not only define for us the operation and the governing that we have in this country, in this state, but they more specifically identify the role of the court in governing, and they express the critical individual rights and liberties that we sit here this morning and every day and enjoy as we strive to become that more perfect union as a nation. The right of the freedom of speech, the right to be secure against unreasonable search and seizure, the right to be free from cruel and unusual punishment, the right to be treated with fairness, the right to be treated with equality, and so many other rights that are with us every day. These are the very rights that unfold in our courtrooms, brought to us by people and considered by courts in our role in this governmental process. These cases, each one of them, some of which you will hear this morning, become a part of who we are and give more meaning and more clarity to those rights that we have, and give us a better picture and promise for our future. This whole process makes us better, and I think that's what our founders had hoped when they came up with this great constitutional process. So thank you again for helping us celebrate Constitution Day. Thank you for your interest in our court system, and again for spending time with us this morning as we do our work on Constitution Day. We do have 4 cases this morning, and the same number this afternoon. But this morning we're going to hear the State of Iowa versus Dale Pettijohn. The second case is Falk Wynn versus the State of Iowa. Third case is Elise D. Stefano versus Apartment Downtown, Inc. And the final case is Karen McQuiston versus the City of Clinton. That last case will be heard, considered without oral argument, and we'll now hear the arguments in the first case, State of Iowa versus Dale Pettijohn. I should just caution, as we transition from the first to the second argument this morning, we will of course excuse the students from the courtroom because you have another activity planned in our building, which is to meet with the Court of Appeals Judge Anu Visasworn in our auditorium, and she'll talk to you in greater detail about this process that you're witnessing this morning. All right, we'll now hear the arguments in State versus Pettijohn, and Mr. Gangestad, you may proceed.
Honorable Justices, Counsel, may it please the Court. Exercising a privilege requires permission. If no permission is needed, then a person exercises a right. On August 18th of 2013, Dale Pettijohn was operating a pontoon boat on Saylorville Lake. This pontoon boat had a sun deck on the back of it, and one of his passengers was sitting on the sun deck, dangling her feet into the water. This caught the attention of DNR Officer Bill Wineland, who decided he was going to stop and seize the boat to, quote, educate Mr. Pettijohn as to why this was a dangerous situation. Mr. Pettijohn was subsequently investigated for boating while intoxicated and was transported to the Polk City Law Enforcement Center for chemical testing. At the law enforcement center, he was read an implied consent advisory. That advisory informed him that he would face, if he refused the chemical test, a $500 to $2,000 penalty and at least 1 year revocation of his operating privileges for boating. As a result, Mr. Pettijohn consented to the test and was charged with boating while intoxicated. This is a perfect case for Constitution Day. This is absolutely, in my mind, loaded with constitutional issues, and even more importantly, gives the court an opportunity to decide some of these issues under the Iowa Constitution. The three major issues in front of the court are, number one, whether the seizure of Mr. Pettijohn's boat and himself personally under Article 1, Section 8 and the Fourth Amendment was valid. The second, whether the implied consent procedure in the boating while intoxicated context rendered his consent involuntary and therefore invalid under the Fourth Amendment and Article 1, Section 8. And third, whether the implied consent advisory that was read to him misadvised him as to the consequences of refusing the test, thereby rendering his consent invalid. Start with the stop of the boat. Officer Wineland stated he stopped Mr. Pettijohn to educate him on why this was a dangerous situation. We don't stop people to educate them. We stop people because we have a constitutionally
Well, didn't he also say he stopped him because he thought he violated the statute involving operating a boat in a manner that was unsafe to the passengers? That's just a summary of what the statute said.
Sure. There are two possible, valid bases for the stop. One, probable cause to believe that a boating violation occurred, and secondly, a possible community caretaking function. The boating violation was alleged under 462A.12 of the Iowa Code, which states that it's illegal to operate a vessel in a careless, reckless, or negligent manner that endangers life, limb, or property. The statute itself focuses on the conduct or manner of operation or the conduct of the operator. If we were to focus on that, Officer Wineland said his manner of operation was just fine. He stated he was not swerving around, he was not changing speeds erratically, he was operating down the channels appropriately. He said the only reason that he stopped the boat was because of the female passenger sitting on the back of the boat. Now, if we were to say that Mr. Pettijohn is responsible and solely responsible for any action that happens on that boat, we'd be criminalizing him for the conduct of another person.
Well, 462A.12.1 talks about it prohibits operating a boat in a negligent manner. Couldn't it be plausibly argued that allowing a passenger to sit in a dangerous position on the back of the boat, exposing her to risk of falling in and getting engaged with the motor or the propeller, is a negligent operation of a boat and therefore a basis for stop?
I believe that there has to be a knowledge component then, that he knew that this was occurring.
Well, if it's negligence, it's not a knowledge component. He's driving the boat. I think it may depend on how dangerous the activity is, but isn't he responsible to make sure that passengers aren't dangling over the propeller? I'm not sure those are the facts quite, and I am interested specifically what the facts are. But if negligent operation of a boat is our standard. He doesn't have to know what's going on. He's got to check from time to time what his passengers are doing.
Sure, I guess I would reply that I guess any time that somebody did something dangerous on a boat, the operator would be criminally liable for that.
Well, was this dangerous?
The whether it's dangerous or not, I think the focus of the statute is whether or not Mr. Pettijohn's manner of operating the boat was the cause of this dangerous situation.
At the time her feet are dangling in the water, was the propeller turning?
I don't believe the record's clear on that. I don't know that the state established that the propeller was turning at the time. Whether he was coasting into the no-wake zone or the propeller was turning at the time, I don't believe that that's specifically spoken to in the record.
Let me, you're trying to define operate very narrowly, the steering, the driving, the propelling, but the statute defines operation broadly because the legislature has provided its own definition of operate, which says means to navigate or otherwise use. So it's not just the driving of it. The statute goes to the use of the boat. And wouldn't you think it would be negligent, violation of that statute, if he was driving in a perfectly safe manner but had 400 people on it? Or driving in that manner with 20 open containers of gasoline on there? I mean, because the legislature has defined it a little broader than what you're trying to tell us it means. So how do you get around the legislature's own definition?
I think if we accepted the definition that any time anybody on the boat was doing something that potentially was dangerous, we start ourselves down a slippery slope. If somebody stood up on the boat and jumped off the boat, that could potentially be a dangerous situation if they jumped toward the propeller.
Okay, so let's go back and get the facts in this case. As I understand it, and correct me if I'm wrong, but the person's at least on the back of the boat, the record establishes that, and that gives rise to a propeller concern, I take it. If someone were dangling their legs in close proximity to the propeller, that gives rise to some serious concern, it seems to me. On the other hand, maybe if someone were distant from the propeller and putting their hand in the water to see how cold it was, that's a different matter. But tell us what the facts are with respect to the negligent or dangerous operation.
Specifically where she was seated, I believe that the testimony of Officer Wineland was simply that she was sitting on the back of the boat. I believe specifically what he said was near the motor. Now, whether that's a foot away, 2 feet away, I don't know exactly how wide the pontoon boat was. I don't think the record is very clear.
I thought he said next to the motor.
He did say she was sitting next to the motor.
Right, and that doesn't mean a foot, 2 feet, or 3 feet,
I think that's open for interpretation as to exactly how far away she was sitting next to the motor, how far her feet were into the water, how far the motor was running in the water.
Does it really matter how far her feet in the water? If he, pontoon boats if he has to make an emergency stop or he has to speed up because something in the water, it would jerk her right off the boat if you're next to the motor. I mean, and there's the federal Coast Guard regulation too. Are you familiar with that?
The federal, yes, the
It
federal.
basically says that's negligent operation of a boat when you have someone sitting next to the motor and interpreting the same statute that we have, but it's a federal statute.
That's correct. The officer stated that if this was a federal case, if this was a federal issue, there is a federal law that prohibits transom riding or bow riding, which would be the back or the front
it
of the
really
boat.
doesn't say that. The federal statute, I know what he said, but if you research the law, the federal statute has almost the same language as our statute. And then there's a Coast Guard regulation that interprets that statute sitting back there. So it's really not a federal statute, it's a regulation interpretation.
Counsel, even if the officer did not have reasonable grounds or suspicion for a criminal offense, what about the caretaking function exception?
The caretaking function or exception, in this case, there would be two sub issues that could potentially apply, either the public servant function or the emergency aid function. The public servant function did not apply here. The public servant function applies when a officer is assisting a boater or a motorist. The classic example that's always brought up in the case law is assisting a motorist with a flat tire. And in this case, there was no evidence that Mr. Pettijohn's boat was disabled, that he was requiring assistance of some kind for a mechanical issue. So it's Appellant's position that sub-context does not apply. The emergency aid exception is the other one that could potentially apply here. The emergency aid name presumes a situation where rendering aid would be necessary. An injured motorist, for example. There was no evidence of that in this case. There was calm water. There was no jostling going on in the boat. Appropriate operation, as the officer had stated. Again, no immediate danger. Officer Wineland stated that he believed that, well, maybe something could have happened.
In past cases, though, haven't we expanded the public servant exception to go check on someone who's fallen asleep in their car, or do something like that? I know there's at least 1 or 2 Iowa cases on that.
I'm not sure that those are under those could certainly be under the emergency aid exception as well.
The emergency aid, we call it public servant, I think.
Sure. I guess in that case there are some objective facts that the officer had, that somebody was passed out in their car, that they needed some sort of assistance. Here there wasn't any indicia that there was any assistance that needed to be rendered.
Let's deal with our Kurth case, fairly recent community caretaking case. How does that cut for you? I mean, the basic facts are that there's been a prior accident, knocking over a stop sign and so forth, and there's some damage to the car. And I won't go into the entire facts exactly, but there was some commentary in Kurth about, didn't need to engage in a seizure, that other activities might have been more appropriate. In Kurth, the officer activated lights and so forth and so on. But it seems to me Kurth is a relatively recent example of how this court has dealt with community caretaking. And why don't you tell us why you think Kurth helps or harms your case?
Sure. Even assuming, for the purposes of argument, that there is some sort of bona fide caretaking activity here, we still need to go to the balancing portion of the test. And the balancing portion says, does the public need to seize the person outweigh their personal right to be free from seizure? And the answer in this case is no. Kurth and I think also State versus Tyler indicate that the officer needs to use the least restrictive means in order to get his point across.
What were the least restrictive means here?
I mean, hey, get your feet up off the boat, or get back into the boat. I mean, that's all he could have needed to do. And if that didn't work, then he can move on to, more intense means of taking care of this situation.
I mean, it's a plausible argument you raised, but I don't really read Kurth that way. The thing in Kurth was that the vehicle was already stopped in a parking lot, and the officer, everybody agreed, the officer could go and check on the driver, tell the driver, hey, you ran over something in the road, you might want to check. The problem in Kurth was, instead of doing that, the officer pulled up behind the car, activated the flashers, and in effect prevented the car from leaving and affected a seizure of a car that was already stopped. The analogy here would be if the boat was docked and the officer then came up and seized the boat and prevented the boat from leaving or moving. Whereas here the boat was moving, the officer, I think, reasonably believed that in order to advise the occupants of what was going on, needed to stop the boat and get their attention.
Well, I think if the officer was able to stop the boat with a visual or audible signal, he would have been able to give a visual or audible signal to say, hey, get back in the boat, that's dangerous, or hey, get your feet up into the boat, without the need for the seizure. The state argued that, well, if we have no idea of knowing whether or not he had those capabilities. If he was able to get the boat to stop, certainly I think he would have been able to give some sort of signal in order to...
But I mean, human reality, human nature being what it is. I mean, when I want to get my son's attention to tell him to do something, I ask him to stop and listen to me. I don't yell upstairs and say, hey, get off your smartphone and start doing your homework. I mean, I'll walk up there and say, hey, you need to be off the phone and doing your homework, right?
I see that I'm out of.
You may answer.
Again, I think we're looking at a constitutional test here, and I think the balancing portion requires that the need to do that outweighs his personal liberty, and I don't think that happened in this case. Thank you, Your Honors.
Thank you as well, Counsel. Mr. Sloven.
Thank you, Mr. Chief Justice, Counsel, and may it please the Court. Good morning. My name is Louis Sloven. I represent the state. 3 arguments on appeal. First, the stop was proper, both because Officer Wineland observed careless and negligent operation of a motorboat in violation of Iowa Code Section 462A12, and because he was acting as a public servant or responding to a potential emergency situation under the community caretaker doctrine. Second, access to Iowa's navigable waters may be a public right, but operating a motorboat on those public waters is a privilege, thus justifying the use of implied consent procedures to keep those waters safe. And third, the implied consent advisory read in this case tracked the statute perfectly. Reading a correct range of penalties did not render the defendant's consent involuntary. Now,
Let's talk about the implied consent issue. There's been a lot of briefing, at least, about the distinction between a right and privilege. At least that's been part of the argument here, and that on navigable waters, you have a right of transit, and historically, in a most general sense, that's kind of true. On the other hand, we do have the analogy with implied consent on highways, and that doctrine is relatively well established. Why isn't there a distinction, though, in the sense that in the manner in which you operate is not subject to licensure? The boat itself, the physical boat itself is, as I understand it, but you don't get a boater's license like you get a driver's license. And so help us with the linkage there.
absolutely, Your Honor. So what we're dealing with here is the distinction, as you mentioned, between a driver's license where you need to be licensed to drive on our highways and boating where you do need to register the watercraft, but you don't need to get a special boating license unless you're under the age of 18, in which case you have to get a safety certificate, which an officer can ask to see. Regardless, it doesn't mean that Iowa couldn't require licensure to use boats on our waterways. At least 5 states do, notably Alabama has an extremely comprehensive system requiring boater education before they license boaters to use their public waterways with motorboats. But regardless of that, I think that the real distinction here is that our public waterways are like our public highways in the sense that the right to use them is a public right. The state has a duty to ensure that that individuals can use the privilege of using those highways and waterways safely, and can suspend individuals' privilege of using those highways and waterways if they present a danger to others.
Well, but that's not, I mean, I've read the implied consent cases. I'm sure you have too. That's frankly not the theory of the implied consent cases. The implied consent cases go into great detail or short detail about the fact that there's a licensure process and that it's a privilege to operate a motor vehicle, and that it's kind of an implied contractual provision, if you will, and so forth and so on. And you've got something else going on here, it seems to me. You're offering a public policy rationale, but it seems to be departing from at least the implied consent framework that's ordinarily applied to motor vehicles. A, is my observation correct, and B, does it matter?
Your Honor, I don't think that's correct about the justification for implied consent in the context of motor vehicles on our highways. All of those cases have said drivers impliedly agree to submit to a test in return for the privilege of using the public highways. Now, there's no real mention of licensure in the discussion that happens in MacIver and Overbay and Hitchens and all the way back through this line of cases. It's all about use.
Isn't that implied consent sort of done after McNeely, after the United States Supreme Court decided McNeely? I mean, the United States Supreme Court, are you familiar with McNeely?
Yes, Your Honor.
I mean, there they said there was implied consent to draw blood without the person's permission, and the U.S. Supreme Court said, well, those laws aren't any good. You can't impliedly give away your Fourth Amendment rights. And they went to actual consent. And the real question is, they went to the voluntariness test of whether or not the consent was given and sort of put that implied consent, that licensing thing on the side. So, and if you follow the cases after McNeely, most of the Supreme Courts around this country have gone through that implied consent versus actual consent. And if they look at actual consent, not implied consent anymore. I mean, isn't that where the law is going?
So, Your Honor, what I would say is that McNeely pertains more to the warrantless overriding of refusal, that when refusal is given and then a sample is obtained against the driver's consent. This is not what we have in this case. What we have is consent given after the implied consent advisory is read.
The state courts afterwards have read that to mean that when someone gives a consent, the statute isn't enough by itself. It has to be, in case of the Fourth Amendment, a voluntary consent. In some states, they go farther under their state constitutions, farther than voluntary. They add a knowingly to it. And that's the direction of the law. I mean, tell me why I'm wrong.
So I don't think that that's really the way that we should be reading McNeely here. I think that what McNeely stands for is the idea that implied consent can't be used to override a driver's refusal, the idea that penalties can be imposed for refusal, and the idea that reading the implied consent advisory doesn't make consent automatically involuntary. Those ideas still stand, and those have been affirmed by this court in cases after McNeely, like MacIver, for instance.
But those arguments weren't made in those cases.
And nor were they made here. This argument is unique to the context of boating. So
I'm not sure that's quite right. I mean, I understand we have a boating case here, but the principles that we're going to be working with are going to have general application. I mean, when we're dealing with particularly search and seizure law, there's not some kind of unique feature of this boating case that's going to control, the outcome here. I don't think. I mean, what's fact specific about this case is the dangling of the legs and where it was and so forth and so on. That's quite fact specific, I think. And we'll look at the record and make a judgment on it. But when we're dealing with consent and the framework for consent, whether there's an implied consent regime or whether you need a Johnson v. Zerps type regime, I mean, that's one of kind of general application, it seems to me. Is it not?
I think that's true, Your Honor. And I think to the extent that the arguments presented in this case call into question the validity of our entire, of implied consent in all of its applications, I think that wasn't, reading the briefs prepared by the parties, it doesn't look like that application of it was really fully argued here, fully developed. But I would say that if this court decides that implied consent is inherently unconstitutional, then that would have to control. I don't think that holding is called for in this case or by the holding in McNeely.
But your view of this, the argument made by the defendant is that this is simply an argument that because waterways are natural and roads are artificial, therefore implied consent shouldn't apply to waterways. It's not a challenge to implied consent as a whole.
That's right, Your Honor. That's how I read this challenge. And what I think is being left out of the defendant's argument is the rest of the sentence from the Lehigh case that's quoted in the brief. Lehigh said that access to waterways is a natural right, but this right may not be abused to the injury of others, and it is the public right that the waters be so used as to return benefits to the people. This is consistent with what our Iowa cases have said about rights to use navigable waters too. The cases that the defendant is citing are about the public's right against riparian owners, but not really about the right of the state to regulate the way in which the public uses the waterways and to pass regulations in order to keep them safe.
didn't McNeely say that in order to get a blood, breath, or urine sample, you have to have a warrant unless you could find an exception to the warrant? And then McNeely they overruled Schirmer, I can't pronounce that case, but Schirmer, whatever it is. They overruled that case and said that dissipation of the blood in and of itself, blood alcohol in and of itself, was not exigent circumstances to get around the warrant requirement. They then said, we're going to do a totality of the circumstances on voluntariness alone. And if you follow the state courts afterwards, they say that the implied consent is part of the totality of the circumstances. And actually, it adds a knowingly thing, because you know what your penalties are before you consent. So wouldn't that be the proper analysis? Because I don't think and I agree with you, it's not the license, it's the operating on the waterway. But, and I think the cases are clear on that when you read them, but that's sort of a red herring in this, because we have to figure out if this was a voluntary consent with the threat of this $500 or $1,000 fine on you, and whether it was knowingly, which is the due process argument, which is incorporated in the implied consent, was the consent that was given this operator correct? I mean, was the operator misled or given false information? And our cases are clear that Mattson and I can't think of the other one off the top of my head, but was the advisory given enough that even if there is some and I think you'll agree with me, there's some stuff left out of it that are wrong. But even if they're wrong, is that enough to vitiate the due process thing? And this implied consent thing is basically sort of down the road, because it's just one of the factors in the totality of the circumstances.
So, Your Honor, I think this takes us into the third issue. I'm going to respond to the substantive due process concern first, and then talk about voluntariness and the totality of the circumstances. So what we have, and this isn't like implied consent in the motor vehicle on the highway case, in that we have in the statute specifically the implied consent advisory that's supposed to be given. Section 462A, 14AG sets out the warning. It was read verbatim. So we don't have the same substantive due process question that we have in those motor vehicle cases where the question is there a reasonable fit between the legislature's intent and the means chosen? We know the legislature's intent. It's to provide this information, the specific information, and the means chosen is to read it. If you want to take a more general view, I know that in the motor vehicle cases, usually we say that the legislature's intent is to provide an opportunity for a reasoned and informed decision. And I think you're right, Justice Wiggins, that folds into the voluntariness analysis the same way it was done in Hutton and to a certain extent in Massengale. So voluntariness, I think, really is the focus of the analysis.
Don't we have a problem, though, because there's two places where the legislature did, and I don't know why they put it in two places, but they put it in 462A, 14C, and they put it in the section you cited in 12, and they're a little different. One tells them to say one thing, and one tells them to say a little different thing. And then if you read the actual statutory penalties, they don't match up with either of them. I mean, doesn't that create a problem?
Well, first, to address the statutory penalties, I think they do match up. And this isn't a case like Massengale where incorrect information was given. This is a case where the advisory that was read, that was set out in the statute, is correct about the range of penalties that the defendant would face. It is a range from $500 to $2,000, and it is a revocation of at least a year. And I get that from Section 462A, 14B, saying that if the defendant doesn't pay the civil penalty within a year, that revocation period will be extended. It's at least a year.
Mr. Sloven, you don't have a lot of time remaining, and let's just for a minute circle back around and address the search and seizure issue. Of course, the overarching law that we have before us is our constitutional provision, which protects all people from unreasonable search and seizures. And let's assume that the DNR officer did not have reasonable grounds to stop based on a violation of the law. And let's assume that he's using the caretaking function as the state has argued in the alternative.
Absolutely, Your Honor. So assuming that...
All right, but let me frame my question this way. Our Constitution, which is the governing principle here, directs us to the reasonableness of the search and the seizure. And so we are ultimately here looking at the reasonableness of the DNR officer's conduct. Now, this is unlike a situation where there's a vehicle which is an enclosed structure, and it's more reasonable to have to stop a vehicle to make this investigative inquiry whether everything's okay. Or like a house where you have to enter the house to make this. Here, there's a boat in a no-wake zone, so it's traveling very slow. It's in the open. Everything is visible. If we're talking about the concept of reasonableness under our Constitution, why isn't it more reasonable for the DN officer to simply do what Pettijohn argues in this case is just drive up next to the boat and say, hey, get your feet out of the water, that's dangerous. And you know, the officer said, it's dangerous because I know there's no guard on that propeller, and I know it's dangerous because I've been an officer for 28 years and I've seen a lot of accidents. Why isn't, under our Constitution, why isn't that a more reasonable way to address this situation other than stopping the vote and then finding out that there's drinking involved?
And Your Honor, my time's expired.
Please answer.
Thank you. So there's one other thing that apart from what you mentioned that the officer knew, this is in his testimony, which is that there's a breakwater in the area that the defendant was driving towards. And a breakwater is an underwater artificial seawall that's built to protect the harbor. So Officer Wineland knew that there was a very real possibility that imminently the boat could be jarred, the passenger could be dislodged, and Officer Wineland had seen the kind of gruesome injury that can result from this sort of thing. So when we're talking about reasonableness, and Justice Mansfield, I think you're correct to point out that divided attention is not really the best way to communicate, especially in this situation where it would involve yelling at the driver, trying to communicate with the driver of this boat in a situation that Officer Wineland knows is already dangerous, distracting the driver with new information rather than just stopping the boat and then dealing with the situation there, having the propeller turned off and then explaining why this is dangerous. I think that's eminently reasonable under the circumstances. And I would also reject the idea that we need to choose the very least the very least restrictive means of accomplishing the community caretaker intent. I think that when we're talking about evaluating our peace officers' actions in retrospect, I think that there has to be some room for acknowledging that they're in the heat of the moment. They have to make a snap decision, and there really is the possibility of grievous injury if they fail to act or fail to act effectively enough. So for all these reasons, we ask that the convictions be affirmed. Thank you.
Thank you as well. Rebuttal?
Thank you. I'd like to respond to the state's arguments regarding the consent issues because we didn't get an opportunity to talk about that on my case in chief. And I think, Justice Wiggins, you're right. I think in light of McNeely, implied consent is kind of hanging in the balance. They've stated that there's no automatic exigency, and probable cause and exigent circumstances are required as a exception to the warrant requirement. And I think what we're dealing with here is whether or not his consent as a whole was voluntary. And we are actually advocating that under the Iowa Constitution that there be a knowing and intelligent component added to that voluntariness.
Doesn't the implied consent notice read to the officer take care of the knowingly part of that? I mean, there's no reason for us to add it under the Iowa Constitution analysis because the statute and the legislature in this wisdom said, we're going to tell you what's going to happen to you if you don't do it. So knowingly is written in the statute. So that basically becomes And we've taken care of that in our other cases under a substantive due process argument. If the notice is bad, and I think you're alleging that too, but if the notice is bad under the statute or under the law, then substantive due process. I don't see a reason in this case, and maybe I'm wrong, why we have to add knowingly to the Iowa Constitution Fourth Amendment analysis when the legislature has done it in the implied consent area. And if we do knowingly, what difference would we do other than look at the implied consent, which we can take care of under the substantive due process or even a statutory analysis?
Well, I think as far as the knowing portion of the, if we were to add knowingly and intelligently into our interpretation of Article 1, Section 8, the Search and Seizure Clause, that would be consistent with with many other constitutional rights that we have in this state. Waiver of jury trial.
I agree with you, but why do we have to do it in this case when the legislature has foisted upon the state the knowingly requirement by reading an informed consent? I mean, I understand your argument, and maybe another day you might catch me on it, but under these facts, why do we, voluntary is enough under the federal Constitution because the legislature has put the knowingly in there.
Well, I don't believe this is voluntary, and I don't...
Different argument.
Sure. And I don't believe that the advisory that's read to the defendant in this case, the appellant, advised him of what would happen. It stated that he would be subject from anywhere from $500 to $2,000. That's not correct. What was correct in this case, would have been his first refusal for boating, and therefore he was only subject to $500 of penalty and a 1-year boating revocation.
It's the second part of the informed consent, that's not a medical malpractice case, implied consent, that bothers me because if you read 462A 14A, it says you have to inform them of the criminal penalties. But if you read 462A 14C, it has a whole different information. And what this consent didn't do, it said, yeah, if you're convicted, you can lose your operating license from 1 to 6 years. But it also said, it didn't say if you're convicted, you can get mandatory jail time and mandatory fines. And that's what bothers me about this, because it didn't comply, number one, with the early statutory requirement that an officer has to say, and it's a harsher penalty than what he was told. I mean, in Hutton, I think we said if you're told a worse penalty and you still consent, there's no harm, no foul. But in this case, my problem is he wasn't told about what happens, fully told about what happens if he's convicted, when the legislature said in 462A 14A, you had to tell him that. So, how do you reconcile those two sections and get knowledge?
I don't think you do. I don't think that he could make a voluntary decision based upon what he was told. I think that just inherently, the implied consent procedure as it applies to boating is inherently coercive. It's inherently, it's classic inducement.
Well, isn't that, I mean, it depends upon what you mean by, quote, voluntary, what you mean by consent. I mean, in theory, one can say if an officer knocks on your house and says, I'd like to search, and if you don't give consent, it's a $500 fine. Is that voluntary consent? But what does it mean to be voluntary? I mean, can there be any consequences for declining to exercise constitutional rights? And if so, what are they? And what were the consequences in this case? I think you see the general thrust of my questions.
I see my time is up, Your Honor.
You may answer.
I think that was kind of a bipartisan question, but I understand. I think here's the big issue with this case. They're told that if they don't waive that constitutional right to withhold the consent, they're going to be penalized. But if they do consent to it, there is absolutely no administrative penalty for them providing a test over .08. But if they're convicted, only once they're convicted do they actually have any penalty there. This is not like implied consent for boating. This is not like implied consent in any other realm. where if they blow over, there's an administrative or special need purpose to it. Here, it's specifically for gathering evidence of a criminal prosecution. And I think because there is no real administrative purpose to it, it's basically at trying to obtain a criminal obtain a criminal conviction here. So I think that definitely plays into whether or not this is voluntary for purposes of whether or not his consent was voluntary in this case.
Thank you, Mr. Gangestad.
Thank you, Your Honors.
Mr. Sloven, thank you. The case is submitted, and we'll next hear Wynn versus State, and we'll stay on the bench, but take a minute or so for the students to leave the room. And thank you again for being here.